Welcome to Immigration Q&A with Attorney Estee. I'm Attorney Estee Aceron Bisnar. I am practicing immigration law, family law, and probate and estate planning here in California, but I'm also licensed to practice law in New York and Philippines. In this segment, I will answer questions about U.S. immigration law. So if you have questions, feel free to email me at attorneyest@aceronbisnarlaw.com, and I will do my best to answer your questions through this segment. Let's get started with our question for this episode from Mr. Bong B of Texas. Attorney Estee, my I-751 waiver application was denied, and my lawyer said he could not represent me anymore. What are my options? Thank you, Bong, for your question. First, what is I-751? Form I-751 is a petition to remove conditions on residence. When one gets his green card through marriage, his green card is conditional for 2 years, unless his green card was issued more than 2 years from marriage. The non-citizen spouse is called a CPR, conditional permanent resident. So within 90 days before the expiration of the conditional green card, he and his spouse must jointly file this I-751 petition. Now, what if due to some circumstances, your marriage did not work out, or your marriage was terminated during this 2-year period? This means you can't jointly file, right? So, the law permits the CPR to request a waiver of the joint filing requirement if the CPR establishes that, number one, removal from the United States would result in extreme hardship, or two, the CPR entered the marriage in good faith, but the marriage was terminated other than through death. Or number three, the CPR entered the marriage in good faith, but the petitioning spouse battered the CPR spouse or child. Some applicants take this petition lightly because they do not know or nobody explained to them the serious consequences of the denial. So what will happen if the petition or the waiver is denied? There is no right of appeal under the law. Your conditional permanent resident status is automatically terminated, and deportation or removal proceedings will be initiated against you, and you will have to appear before an immigration judge. Now, there are many lawyers who are assisting clients with the USCIS petitions who may not be practicing before the EOIR, or the Executive Office for Immigration Review. Lawyers must register with the EOIR before they will be allowed to practice. Hence, some lawyers would prefer to assist only with the initial petitions. So let's go back. Before the removal proceedings, are there options you can take? As I mentioned, there is no right of appeal, but you can file a motion to reconsider within the prescribed period if you think your denial was based on incorrect application of law or policy. Or second option is to file a motion to reopen if you have new facts or evidence to support your I-751. Another option is to file another I-751 waiver petition before the USCIS. While joint I-751 petition must be filed within 90 days of the date that your original conditional permanent residence expired, I-751 waiver may be filed at any time, as long as the U.S. immigration judge has not entered a final order of removal against you. Option 4. When you are before the immigration judge, you can request the immigration judge to review the denial of your I-751 petition. Hearings will be conducted, and you and the government will present evidence to support your respective contentions. Now, if the IJ denied your I-751, you may appeal with the BIA, or the Bureau of Immigration Appeals. And if the BIA affirmed the IJ's decision, then you will have to file a petition for review before a federal court, which has jurisdiction over the case. For example, if the hearing was conducted in Los Angeles, then the 9th Circuit Federal Court of Appeals will hear your case. Again, not all lawyers could practice here. Lawyers have to apply and register. Unlike in other countries, like in the Philippines, being a lawyer, you can practice in any court. So, many lawyers do not even register because they do not plan to practice before the federal court. That's why some applicants have to engage another lawyer to file the necessary petition. So you will realize that this I-751 petition is no joke. You will have to really prepare diligently. Modesty aside, all my clients do not have to bear this agony. They were not even asked to appear for an interview. Their petitions were approved by the USCIS just by evaluating the documents submitted. That is why when I took over some cases handled by some lawyers or others without engaging any lawyer, I really feel bad that in the initial stage of the proceedings, while they had all the chances to prove their case, they miserably failed to submit what the USCIS was looking for. Thus, when I reviewed their case, I totally understand why the USCIS denied their petitions. So as a lesson, you think you are saving by not consulting with a lawyer? Think again. You are risking your future by not doing so. Also, approach a lawyer who will really fight for your case till the end and not just take your money and leave you in the dark after the initial stage of your fight. Many have been deported due to their failure to substantiate their petitions. So this is really serious. That's it for now. Please remember this segment is to provide information and general views about U.S. immigration law. This segment is not intended to provide specific legal advice. Every case is different, and so it is always advisable to consult an immigration attorney. You can check out my YouTube channel, AWithAttorneyEstee channel, for more information about U.S. immigration law. And for a free consultation, you can email me at AWithAttorneyEstee@aceronbisnarlaw.com or visit my website at www.aceronbisnarlaw.com. See you in the next episode of Immigration Q&A with Attorney Estee every first Friday of the month here at Spotlight TV on KSCI TV LA 18. Bye!